Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Welcome to our second day of the winter course of International Law. My name is Lucas Lima. I'm a professor of International Law at Federal University of Minas Gerais, Belo Horizonte, where this course normally occurs. When Professor Nemer invited me to introduce Sir Michael Wood, my immediate reaction was, Sir Michael Wood needs no introduction. Be that as it may, protocol suggests that I highlight his main achievements and contributions to international law. So Sir Michael Wood is a member of the International Law Commission, which is the organ of the United Nations responsible for codification and progressive development of international law. He was the principal legal advisor to the Foreign Office between 1999 and 2006, UK Foreign Office, of course. During his 35 years as a Foreign Office lawyer, Sir Michael attended many international conferences, including the UN Conference on the Law of the Sea, and he spent 3 years at a UK mission to the UN in New York, dealing chiefly with Security Council matters. Since leaving the Foreign Office in 2006, Sir Michael has acted for many governments in cases before the International Court of Justice, European Court of Human Rights, an International Tribunal for the Law of the Sea, and Interstate Arbitral Tribunal. Sir Michael very kindly accepted to give 2 lectures for us. Today he's going to talk about the International Law Commission and the sources of international law. And on Thursday, he will discuss one of the most stimulating topics under the ILC study, which is the identification of customary international law. And Sir Michael was a special rapporteur on this topic before the ILC, and much of the final ILC conclusions on this topic can be traced to his leading role in this position. Since the 20s, the members of the Advisory Committee of Jurists responsible for drafting the Statute of the Permanent Court of International Justice, the topics of the sources of international law has sparked debate within and outside the international legal field. This is not so only because sometimes the identification and precise content of sources can be elusive. There is also the fact that the topic has intertwining elements with the whole conception of the international legal system. The contribution of the ILC on this topic is enormous. Let's just consider that some of these issues were already in Sir Hesh Lauterbach's suggestion on topics in the early days of the Commission. Not to mention the significant contribution to the ILC on the law of treaties and its many subdivisions, and such as reservations, subsequent practice, and other topics. Very recently, the ILC has moved to the study of the process of identification of different sources, customary law, general principle, and if one looks closely to the ILC reports, one may find interesting sayings about judicial decisions and the role of the work of publicists. So Michael will today, in the next hour, will shed some light in this interesting move. After that, we shall have a Q&A session, and students are invited to send their questions that I will, after that, put to Sir Michael at the end of his presentation. Sir Michael, it's an honor to have you here with us this week, and it's needless to say that we hope to see you in the very future at Belo Horizonte when this terrible situation will be under control. Please, Sir Michael, you have the floor, or better, you have the screen.
Well, thank you very much, Professor Lucas, for that kind introduction. It's certainly a great pleasure to take part in this international law winter program. I looked online, and winter in Belo Horizonte seems to be like summer here, except here it's much colder than in Belo Horizonte, even though it's our summer. It's a great pity not to be present. I have very happy memories of visiting Brazil. I've been a few times, including to Belo Horizonte and to Minas Gerais, Ouro Preto, and all the very nice places that one can visit. But it would be great to come again. I propose to speak for about 45 or 50 minutes, if that's all right, and leave plenty of time for your response, if any, and the questions. I'd rather have a discussion than just talk all the time. You'll have noticed that both my talks today and on Thursday relate to the sources of international law. And that's quite deliberate. I believe that it's essential for international lawyers to have a very clear and reasonably deep understanding of the sources of international law. I remember when asked by the judiciary in England whether they should have courses in international law, we said, well, all you need is a course on the sources. You've got to really understand the sources of the law, and then the barristers, the lawyers who appear in front of you will be able to explain the substance, but you must understand the sources if you're to really give a correct and proper answer to the questions of international law that come before you. Article 38 of the statute, which you've already referred to, is absolutely fundamental. And I remember when I studied international law at Cambridge, my hero, Professor Clive Parry, said, all you need to know is Article 38 of the statute. Question 1 in the exam will be, what are the sources of international law? And you write down Article 38 of the statute. And sure enough, when it came to the exam, question 1 was, what are the sources of international law? and we got good marks by writing down Article 38. I'll come back to that in a bit more detail. A point that I'm going to try and get across is that, in my view, the work of the International Law Commission is in some ways more important than the work of the International Court of Justice. That may be surprising because we all worship the International Court of Justice, we read its judgments, we think it's the highest body in international law. Indeed it is, in a sense. It's one of the 6 principal organs of the United Nations. But what does it actually do compared with the International Law Commission? In my view, the International Law Commission is in some ways more important, and that's not necessarily a compliment, because it doesn't necessarily do good work, but it does important work. And I'll come on to that in a minute. Just to recall that Brazil has been very well represented by its international lawyers on the International Law Commission. I checked this morning and I found, somewhat to my not surprise, but it was interesting, that Brazil has had a lawyer on the International Law Commission for longer than any other state other than the Soviet Union and Russia. Others, like the United Kingdom, France, the United States, China, have been absent for more years than anyone other than Brazil and Russia. And the Brazilians who've appeared, who've been on the commission, have been very well respected. Just to mention them, there's Gilberto Amado, followed by Sete Câmara, who then resigned upon becoming elected to the International Court of Justice, and that's where the gap took place. Barbosa from Argentina was elected to replace him. Then we had a good friend of mine, Carlos Calero Rodriguez, João Baeira Soares, I'm not very good at pronouncing, and now we have Gilberto Saboia, my colleague. So these 5 great names of international law have played a major role in the International Law Commission. I think it's quite remarkable that they have been, dare I say it, virtually permanent members of the International Law Commission. Brazil's support for the Commission is also very apparent. There's the Gilberto Amado Memorial Lecture Series, which happens every few years, and Professor Nemmer, Professor Brandt, I'm not sure how one refers to him, from the center in Belo Horizonte, gave that lecture a few years ago. I'd also say that Portuguese speakers have played a large role in the Commission. When I first joined the Commission in 2009, there were 3 Lusophone members, in addition to Saboia. There was Paula Escaramea from Portugal and Pedro Comissário Afonso from Mozambique. So Portuguese was very much a language used in the Commission. And now there are 2 very active members, Gilberto Saboia and Patricia Galvão Teles from Portugal itself. Now, I was going to speak really in 4 parts today. Firstly, briefly to introduce myself, but you've more or less done that, so I won't say very much about that. Secondly, to say a word about the sources, but everybody knows about those. So really, I'll just try to give you my view on them. Thirdly, I'll say something about how the International Law Commission operates in practice. And fourthly, I'll just summarize how much work it has done in relation to the sources of international law. So first, a word or 2 about myself. I do consider myself to be a practitioner, mainly in the field of public international law. I've never been a professor or a lecturer, so I'm not used to being called Professor Wood. I do remember Professor Brownlee, when he retired, used to get very angry if anyone referred to him as a professor. He said, "I'm not a professor. I'm a an advocate. I spent some 35 years in the British diplomatic service as one of the legal advisors. It sounds rather dull to spend 35 years in a job. Nobody does that these days. But in those days, people did stay in their jobs. But I had plenty of opportunities to go abroad. Many years spent at the Law of the Sea Conference. I spent some months in Zimbabwe in 1980 in the lead up to its independence that year. And I spent 3 years in Germany dealing with the legal questions of Germany and of Berlin under the four-power regime following the Second World War. And then 3 years at the mission to the United Nations in New York, which was the hardest work, mainly the Security Council when it was really busy between 1991 and 1994. As you said, I was legal advisor, the chief legal advisor to the Foreign Office from 1999 to 2006. It was just after the Kosovo intervention. So I prayed for 5 or 6 years of peace on earth. And what did we have? We had 9/11 and the intervention in Afghanistan and the war on terror, as my American colleagues called it. And then we had the 2003 Iraq war, which raised a few issues and has been the subject of a very interesting inquiry in the United Kingdom, where I was able to explain in some detail that my advice had been that it was unlawful to join in the invasion of Iraq in 2003. If we hadn't had an inquiry, I wouldn't have been able to say these things. Since I left the Foreign Office in 2006, I've been a private lawyer working for governments on the whole. And I have to say that working for other governments is just like working for the British government. They lose the vital documents. They don't know what they want. They're all the same. There's no difference between working for Equatorial Guinea or working for the United Kingdom government. But I have had the pleasure of working for quite a few Latin American states, including all at the ICJ, in fact, Honduras, Peru, and now Colombia and Guatemala. I'll now turn briefly to the sources of international law. And I will be brief, as I said, because everybody knows what they are. But they're often misled by academic writings on the subject, in my view. In my view, it's really quite clear. Article 38 of the statute, although in a formal sense, all it does is say what law the International Court shall apply, is recognized by all right-thinking international lawyers as a statement of the sources of international law. I would say as a complete statement of the sources, and I'll explain that very briefly. But those who come up with new ideas and say, well, it's very out of date, it's 100 years old, etc., I think you should treat them with some suspicion. There's a tendency for writers to want to say something new. And almost by definition, if you say something new, you're saying something wrong. I don't want to discourage new ideas, but they tend to not be terribly helpful. The statute of the ICJ in Article 38, of course, has been reproduced in many treaties, either verbatim, as in the Pact of Bogotá, and in the Council of Europe's Dispute Settlement Convention, or in a modified form in the Rome Statute of the International Criminal Court. So I would say that it's a clear and good statement of the sources of law. People say, yes, but what about binding decisions of the Security Council? Well, binding decisions of the Security Council are binding because of a treaty. So they come in with under the heading international conventions. The obligation to comply with them flows from the UN Charter. Then people say, well, what about unilateral acts of state. Well, it's a bit more difficult there, but I think there you can just say, well, there's an international rule, a rule of customary international law that unilateral acts of states are binding, therefore they can fit into the rules of customary international law. Just a quick word about general principles of law. Well, I'll come on to that later, perhaps, but they've hardly been noticed. They've hardly been touched on until recently, or in the hands of a few writers. So it'll be interesting to see how that third and last source of international law takes off, perhaps. And then, of course, there are the two things, decisions of judicial decisions and teachings, which are not really sources of law. They're a way of finding the law. They're an assistance, they're an auxiliary means, as it says in French, which is actually better than the English, which talks about a subsidiary means. There's nothing very subsidiary about them, they're very important, but they are auxiliary in the sense that they are there to assist you. And if I were to recommend anything on sources for students, I would say you should read, because it's very short, Hugh Thirlway's book on the sources of international law. A second edition was published last year, shortly before he sadly died. But that is a very good book, in my view, on the sources of international law. Now, I'll turn to the International Law Commission and say a few words about that of a general nature. As I've said, I think it's in some ways more important than the International Court of Justice, but that's not to complement it. And that's almost a warning. I have written that the Commission is a potentially dangerous place. That was my phrase. Careful, potentially dangerous place. I said it's not dangerous in itself. It's the attitude of others, including courts and tribunals, that makes it dangerous, in the sense that undue homage is sometimes paid to its work, whether that work is good, bad, or indifferent, and whatever stage it has reached. So really a word of caution about relying upon the work of the International Law Commission, and a word of caution for the Commission, because its work is given considerable authority, or regarded as having considerable authority. The Commission itself, in my view, needs to be very careful indeed in what it produces. Just to give an example of the abuse, in my view, of the work of the Commission, a few years ago, the highest Swiss court, the Swiss Federal Tribunal, made a decision or issued a judgment about the immunity of the defense minister of Algeria. And in determining whether there were exceptions to the immunity ratione personae of a minister of defense, or whether a minister of defense had the same immunity ratione personae as a foreign minister, according to the arrest warrant case, the Commission, the Swiss Federal Tribunal, quoted at some length from the International Law Commission. But what it quoted were the speeches made by individual members of the Commission in a general debate. And it said the Commission said this, the Commission said that. In fact, it was what some of my colleagues had perhaps wrongly, perhaps rightly, but it was their individual views. So it's an indication that you do have to be very careful when looking at the work of the Commission. And I'll come back to that. A word about the membership of the Commission. It's currently got 34 members. They sit in their individual capacity. They're elected by the General Assembly of the United Nations. And we all know that elections at the General Assembly of the United Nations are highly political. They're based upon deals. They're not necessarily based upon merit. What really matters is that governments put forward good candidates, because the election process doesn't necessarily mean that the best candidates are elected, but if good candidates have been put forward in the first place, then you will get good people on the commission. And on the whole, I think there have been good people on the commission. Now, who are they? If you look very roughly at who these people are, I think about 50% are academics and about 50% are practitioners, often former government lawyers, lawyer diplomats, or even serving government lawyers. The current Russian member is the legal advisor to the Russian Foreign Ministry. The Chinese member was the legal advisor to the Foreign Ministry and is now, I think, still a Chinese diplomat. But quite a lot of these people are both. They're both practitioners and academics. So my 50-50 is pretty rough. I'm just putting people in one class or another. Where would you put Professor Alain Pellet, for example? I think I put him as a professor, but of course he's also very much a practitioner. So it's about 50-50, and I think that's good. Some people say, Professor Pellet says, there should be more academics. We don't want these people who are influenced by their government. They're just speaking for their governments, even though they're independent, he might say. But actually, it's very important on the Commission to have the right mix of practitioners, people with a practical knowledge, and of academics. Just a few other people who are very important in the Commission. The members of the Secretariat are very important. They're from the Codification Division in the Office of Legal Affairs of the United Nations. And these are very well qualified, very able international lawyers who've often been for many years in the UN system. They write for the Commission extremely valuable studies. I was looking at one just a few years ago on diplomatic asylum, not a subject that you find much about in the books, but we had a slight problem at the Ecuador embassy here in London. And the best thing that was written on diplomatic asylum, in my view, was the Secretariat study dating from about 1974. They did a very good study, which I think was written by Santiago Villalpando, on the aut dedere, aut judicare clauses in international conventions, which we used quite extensively before the International Court of Justice in the Belgium-Senegal case. It was really very helpful because these are very well done. They're very carefully done. They're neutral, but they've been done with great depth. And these codification memoranda are very useful. Another important group of people on the Commission in recent years are young lawyers who act as assistants to the members of the Commission. I've had an assistant from my second year. I didn't the first year because I had no idea what I was to do, so I didn't know what an assistant would do. But they have been very useful, and I would mention a very good, in my view, very able young Brazilian, Fernando Bordin, who I think assisted Giorgio Gaia on the Commission when he was working on responsibility of international organizations. And I think Fernando's book that came out in the last year or so on analogy between states and international organizations drew quite a lot on his experience with the Commission. And I'm pleased to see that it got an American Society Certificate of Merit earlier this year. It's really a very good book. Another group of people associated with the Commission are the International Law Seminar. This has been going on for 50 years or more. And there's about 30 young lawyers, 25 young lawyers from all over the world come for a 3-week seminar at which members of the Commission talk to them, but they also visit other international organizations in Geneva. And that's a very good experience. I would recommend that to anyone who's interested in finding out about the Commission and the UN and Geneva, quite a lot of members of the Commission were actually on that seminar 30 or 40 years ago. It's quite interesting. They always welcome the seminar members saying, I used to be on this seminar. So it shows that, that it's a good thing to be on. It's often young government lawyers, but also young others. So if we go back to the International Law Commission itself, the most important thing I would say about it is that it is not a legislature. It has no powers to legislate. This is very clear if you look at Article 13 of the statute of the UN Charter. It says that the General Assembly's role includes promoting the progressive development of international law and its codification. And the statute of the Commission uses the same words. So the job is to promote. It's not actually to legislate. People misunderstand that, and that's part of the problem I see with people giving too much authority to the Commission. But it's very important to note that its role is only to promote the progressive development and codification of international law. And what really matters, in my view, or what should matter, is the reaction of states to the output of the Commission. If the Commission comes up with something bad, which occasionally it does, states should say so. And they should say so in as undiplomatic a way as they can in the UN General Assembly. And then the danger of these texts becoming too authoritative will be reduced. So that's a very important first point. The second point, which I've already mentioned, is that in order to know what weight to give to the various documents of the Commission, you have to understand its working methods. I indicated that the Swiss Federal Tribunal failed to do that a few years ago. I'd contrast that with a very interesting decision of the District Court in The Hague in January this year, also on the subject of immunities. And they looked very carefully. This was the immunity of two very senior Israeli military officials, including Gantz, who's now, I think, not quite prime minister, but a kind of joint figure with Prime Minister Netanyahu. It was a civil case, so quite interesting, and it arose out of bombings in Gaza. But the District Court in The Hague, in my view, very ably looked through the work of the International Law Commission on the subject of the immunity of state officials from foreign criminal jurisdiction, which was they were looking at by analogy with the civil immunity. And I recommend that. It's available in English. The Dutch courts are very good. They produce their good judgments, at least in English, on the same day, actually. So I'll say a word about the way the Commission works, and it's not without its problems. And the first problem, and perhaps the biggest problem, is how to select the subjects that we deal with, how to select the topics. It was envisaged, I think, that states would ask us to do things, that the General Assembly would ask us to do things, but they hardly ever do. And so the Commission itself has to come up with topics that it thinks are suitable, which depends very much upon individual members of the Commission deciding that they're keen on something, like the identification of customary international law, to take an example, and proposing it, and then it gets examined, and most of the topics that are proposed get thrown out. They don't get taken up, but they get looked at very carefully, but a few slip through. And among the ones that slip through, some are good and some are not so good. But the procedure, which is a very long and careful one, doesn't always come up with good results. So there's a problem with the topics that are taken up. And once a topic's taken up, it's very difficult to kill it off or to bury it. We did that recently, well, a few years ago, with the topic of aut dedere aut judicare, which was taken up. The result was not a success, but it was actually useful because, as I've said, we got a very good report out of the Secretariat on the subject. So it wasn't a useless topic, but it didn't lead to any good results. So firstly, you select a topic and you appoint a special rapporteur. The special rapporteur is usually the person who's been pushing for the topic. Then there's a series of annual reports by the special rapporteur. Annual reports if the special rapporteur gets on with it. Sometimes they don't. They fail to produce a report. And then the Commission can't operate because the special rapporteur is really the motor of the Commission. So occasionally topics drift for a little while because special rapporteurs haven't succeeded in coming up with an annual report. And then once we have an annual report from the special rapporteur, we have a debate in the Commission. And this is quite important. It's very formal. It lasts usually a whole week, mornings, when most members of the Commission, maybe 20 or 25, make quite long speeches about the report, usually highly critical. We always start off thanking the special rapporteur for his excellent report and then attack it. And it's very outspoken. It's not diplomatic at all. It's good fun. I think it's an enjoyable part of the process, and it's all recorded. It's all published. There's a very full summary record. It's called a summary record, but it's virtually verbatim. I did ask why we didn't have verbatim records, because it would be cheaper, because summary records you have to have précis writers. And somebody pointed out that some people do talk complete rubbish, so it is quite important to be able to omit large parts of what a few members of the Commission say. So that's why we have summary records. So after the debate comes the really important part, when the proposals from the Special Rapporteur get sent to the drafting committee. Now, the drafting committee is where all the work is done. The drafting committee deals with substance. It deals with drafting as well, but it's mainly dealing with substance. It's where the negotiations take place and the really ridiculous ideas are disposed of. Completely new thoughts come in, and a text comes back from the drafting committee, which often bears very little relation to what the Special Rapporteur proposed. And if you look back, this was always the case. You know, great lawyers like Sir Humphrey Waldock would come up with careful drafts on the law of treaties, and the drafting committee would throw them out, turn them upside down, come up with something completely different. That happens still. And I think that's good. I must say my experience is that a collective output is much more useful than an individual output. I'm not sure what that says for people doing PhDs, but in any event, I do think that collective work leads to really useful results. So the drafting committee is where all the negotiation takes place. It's in private. No one's allowed in except these assistants that I mentioned earlier. They come and they can nowadays, of course, tell us what to say because we have internet connection with them. So they say, don't say that, say this, propose this. And assistants can be very, good ones can be very active and effective, even in the drafting committee, because they can talk to you over your laptop. Then a text comes back from the drafting committee and is adopted by the plenary, usually without any change. But then comes a critical stage, which is where the Special Rapporteur is expected to draft commentaries on the text. And these commentaries, as you know, are very important. The output of the Commission is the text of the articles or conclusions plus the commentaries. And you can't read the texts without the commentaries, essentially. So the commentaries are vital, but they tend to be drafted at the last minute. There's very little time for people to comment on them. The other members of the Commission have to comment on the commentaries during the adoption of the report at a public meeting of the Commission, which lasts for about 2 weeks, adopting the report, when we're trying to improve the commentaries. But there's a limit to what you can do in public. If you read those records, which are public, you find that a lot of changes are made, but not enough. For example, last year we made a huge number of changes to the commentaries on Jus Cogens, and I thought we'd done a really good job. I now read the commentaries on Jus Cogens, and I think there's quite a lot more work to do. But don't tell Professor Tladi that unless he's listening. So this procedure for adopting the commentaries is, I think, not at all satisfactory. They're done in too much haste. We've tried to remedy that. James Crawford, with the commentaries on state responsibility, actually set up a working group on commentaries that met for a week before the Commission. And that was a very sensible thing to do. And we have tried to have working groups on the commentaries. I tried that with the commentaries on customary international law. And I think it worked to some extent. And then, of course, the most important thing to know about the Commission is that it does a first reading and a second reading. And only the second reading of any text is final. And the importance of that is that states are expected to comment in detail between the two readings. When they have the first reading text, they're given 2 years. There's a year's gap in which they comment in detail. For example, last year we adopted the text on Jus Cogens on first reading. States have until the 1st of December this year to comment on that text and the commentaries before we do the second reading, which we should be doing in the next year or two. That interchange between the International Law Commission and states is absolutely essential. It doesn't always work very well because states and their lawyers are very busy. They sometimes don't feel able to comment. They sometimes don't want to comment because they want to keep their options open. But nevertheless, it's a very important part of the Commission. And it's really what distinguishes the International Law Commission from private bodies like the Institut du Droit International or the International Law Association, which often do similar topics and even have similar output, but they do it without any input and without this exchange from states. States often don't submit comments, but some of them do. Perhaps it's a bit unbalanced. Those that do tend to be the same ones, often from Western Europe or North America or Australia, but that can be improved. And actually, in the Sixth Committee itself, where there's a 2-week debate every year, a lot of states, maybe 60 or 70 states, comment in some detail on the work of the International Law Commission. So that's almost more useful than the written comments from states, or you get a better variety. The records of the Commission, the written records, are very important, and they're done with great care. And they're all available on what is an excellent website, the International Law Commission website that the Secretariat prepare is usually absolutely up to date, absolutely accurate. You can get access with a click to any document of the Commission. So anyone doing research into the work of the Commission just has to click on research, and then there's a subheading analytical guide, and that will give you everything on, let's say, Jus Cogens so far, with a click to every report, to every debate. So I think it's very well documented, the Commission, which is important because these documents are really the travaux préparatoires of the final output of the Commission. So I think there are a number of problems with the work. The choice of topic is problematic quite often. The adoption of the commentaries is problematic. The speed with which we work is sometimes criticized, but I must say I think it's better to be slow and careful than to do things too quickly. I think if the special rapporteurs change, as they did with the law of treaties, 4 different special rapporteurs, that can be a good thing. It gives a different perspective each time there's a change of special rapporteur. So I don't see that as necessarily a disadvantage. A very difficult and recurring problem, which I don't really have time to go into, perhaps in the next lecture, is the distinction between the progressive development of international law and the codification of international law, where the Commission statute says we have 2 different procedures, which we never follow. But it comes down to the question, is the output of the Commission meant to be lex lata, or is it lex ferenda? And we're often asked to be clear. It's often very difficult to be clear because we don't agree among ourselves. But it can be very important. And an example where it is very important is the current very contentious topic on the immunity of states from foreign criminal jurisdiction, where we said there are some exceptions to immunity ratione materiae, to official act immunity, exceptions for crimes against humanity, genocide, aggression, etc., etc. Is that lex lata, or is it lex ferenda, or is it, I would say, lex desiderata? It's what some members of the Commission want the law to be. Can we say, well, sometimes we all give our individual views, but can the Commission give a joint view? But even giving individual views can be quite important, I think, for the eventual assessment. And that's something that this Dutch court looked at very carefully in connection with the immunity of former officials for alleged war crimes. Now, just very quickly, to come to the subject of the International Law Commission and the sources of international law. I really, under this, just wanted to give an overview to show how much the Commission has done in this field. There are 2 angles, really. Firstly, one could study the Commission's work to see how the Commission itself has used the sources of international law, what its view is in its own work. And that's very difficult to do, obviously. But the Commission, or the Secretariat, did that in connection with customary international law. And they produced a very interesting memorandum in about 2012 or 2013 on the role of customary international law in the work of the Commission. And they divided that up and came up with about 20 guidelines, they called them, which are very similar to the conclusions that the Commission eventually came to. And they derived this from looking at the work of the Commission, how it had used the sources of international law. But it's not so much that I wanted to talk about, but it's the range of sources which is dealt with directly. And just to run over them very quickly, it starts with Article 24 of the Statute of the Commission, which you'll all recall, says that the Commission has to study ways and means for making evidence of customary international law more readily available. And this was one of the first tasks that the Commission did in 1949 and 1950, and produced some very interesting documents about what evidence of customary international law was. But the important consequence of its studies was that the Secretariat were then instructed to produce a number of publications that are still very important today. They published the Recueil of International Arbitration Awards. That was a direct result of the study by the International Law Commission to make the evidence of public international law, of customary international law, more readily available. They published the various legislative series, volumes on things like the law of the sea, diplomatic immunity, and other things. There's a whole series of documentation which is still going that resulted from this study by the Commission under Article 24 of its statute. But then turning to its own study of sources of international law, it's really very interesting to see how this started. If you look at the famous Secretariat Survey of International Law from 1949, it's often called the Lauterpact Survey because it was prepared for the Secretariat by Hirsch Lauterpact. This was a survey of international law in relation to the work of the International Law Commission to try and decide what subjects the Commission should take. And I'll just read out what it says about sources of international law. It's very dismissive. It's one short paragraph. It says, the codification of this aspect of international law has been successfully accomplished by the definition of the sources of international law in Article 38 of the Statute of the International Court of Justice. I agree with that. There's nothing else to do. Article 38 of the Statute of the International Court of Justice has actually dealt with the question of sources. There's nothing more to do. And they went on to say, that definition has been repeatedly treated as authoritative by international arbitral tribunals. It is doubtful whether any useful purposes would be served by attempts to make it more specific, as for instance by defining the conditions of the creation of the continued validity of international custom, or by enumerating, by way of example, some of the general principles of law to which Article 38 refers. Very interesting. So they basically said, don't touch the subject of sources. It doesn't need any more definition than Article 38. The British Institute of International and Comparative Law did a study in about 1980, something like that, 1990s, on what the international law should do. This was a time when nobody could think what the International Law Commission should do. And the British Institute's report says very clearly, whatever you do, don't discuss the sources of international law. Don't discuss customary international law. There's no point in doing that. So it's very interesting that quite recently, this was the view. But obviously, things have changed quite a lot in the last 20 years. Just very quickly, the various topics where the Commission has dealt with sources. The law of treaties is an obvious one. It has to be said that even Lauterpact's survey had a separate section on treaties saying, yes, we must deal with treaties. Quite how he fitted that in with what he'd said earlier, I don't know. But he was a good diplomat as well as a lawyer. But of course, there's so much on the law of treaties. We all know the three Vienna Conventions. I won't go into them. Reservations to treaties, already discussed by the Commission in 1950, and the International Court rejected its view and came to its own rather curious view, which we're stuck with, which I think is the Latin American view, probably, if I can put it that way. And then we have Professor Pellé's Guide to Practice on Reservations to Treaties. This is 650 pages long. It's very useful, no doubt, if you have a problem in a court about reservations to treaties, which seems to come up about once every 20 years. But it's very well done. It's very useful. It's 650 pages long. I was very proud that when I did customary international law, I managed to get it into 45 pages. I think 45 pages is better than 650 if you want judges or even professors to read it. But also in the field of sources, we've dealt with MFN clauses. I think that probably counts as sources. We're currently dealing with the provisional application of treaties, which is a very important question, particularly for a state like the United Kingdom, which has just left the European Union and has to enter into a whole series of important treaties very, very quickly. There was the topic effects of armed conflicts on treaties. not a subject that comes up very often, but which is nevertheless of great interest, and quite an interesting set of articles were prepared by Professor Brownlee and Professor Kaflish, followed by Professor Kaflish. And then recently, of course, we did, under Professor Nolte's guidance, subsequent agreements and subsequent practice in the interpretation of treaties, which I thought was a really boring subject, but it turns out to be a really useful set of draft conclusions with commentaries, which I refer to frequently. Then we did customary international law, which I will talk about next time. We're currently dealing with Jus Cogens. We've also taken up very recently general principles of law as recognized by civilized nations, but we don't use the term civilized nations if we can avoid it. That's at a very early stage. I think the special rapporteur, Vasquez Bermudez from Ecuador, did a really good job in his first report. And we had a really good debate last year, and we made a little bit of progress, but these topics always start slowly. But I found he really managed to clarify matters. There's a lot of nonsense talked about general principles of law, including very recently in some recent books. But Vasquez Bermudez did really well, I think, in producing a first report. He's now produced a second report, and I'll refrain from commenting on that. I do have some serious doubts about it, but of course, we've yet to have the debate in the Commission. It'll be very interesting to see what comes out of it and what is left of it when we've had our debate and it's been through the drafting committee. So general principles of law, I think it's a really interesting and exciting topic. In a way, taking it up gives them more prominence and might lead to them being referred to more often. I'm not sure that's a good thing, but nevertheless, it's a bit the same with Jus Cogens, in my view. Then, in the past, the Commission dealt with principles applicable to unilateral declaration of states and came up with some fairly innocuous draft conclusions, or guiding principles, rather, on that subject, which I thought weren't terribly useful, but the International Court of Justice has actually quoted them and found them useful. More generally, there was the work of the study group on the fragmentation of international law, which addressed many issues relating to sources such as hierarchy, the principle of harmonization, this kind of thing. So, in fact, despite what Hirsch Lauterpacht said back in 1949, the Commission has really done a lot of, in my view, very useful work on sources in the last 20 years, the last 10 years. Why do I think it's useful? I think the fundamental concern I have, as I said at the outset, is that people don't necessarily understand the sources, and particularly the many lawyers who are not specialists in public international law, but who have to decide or consider questions of public international law. And I'm thinking especially of judges in the domestic courts. For them to have something that's reasonably authoritative from the Commission on these subjects is, in my view, very helpful and will help them find their way through the thickets of academic speculation. The judges in England, I discussed with them, they were very encouraging to have the topic of customary international law dealt with by the International Law Commission, but they said, actually, it would be much more useful to have Jus Cogens dealt with by the International Law Commission, because it's always being raised in our courts and we don't know where to look. We don't understand it. So with that, I think I've spoken longer than I intended, but I've left half an hour or so. Is that right? I'll finish there, and over to you, Professor.
Thank you very much, Sir Michael. Sometimes when we read dissenting or individual opinions of judges of ICJ, it's like to going behind the bench and to see behind the curtains what is going on. I think that your conference gives to us something like that regarding this private and not so public meetings in Geneva and how the ILC works. We had more or less 700 students watching us and were hearing you, and we have a lot of questions. I have to select some of them. I will put them in the next 30 minutes. But before we start the student questions, and please, for those of you that are following us, feel free to continue to ask questions. We are selecting them. But you mentioned several very interesting issues on your presentation. And one of these is the relationship between the topics of study of the Commission. For instance, we had the conclusions on customary international law, which will have certain influence on the project on principles and, of course, in use cogents. But you have different special rapporteurs conducting the work, and you have perhaps different perspectives. Only to mention Gladi and Vasquez Bermudez perhaps could have different perceptions. And this is also connected to a question from a student from Minas Gerais, Rodrigo Franco, which is, what about the coordination between the ILC and the Sixth Committee? Would this be welcome to attenuate this legislative perception of the Commission? So I think that this is a good start, having your words in these two general questions: relationship between topics and dialogue with the Sixth Committee.
Well, we're very conscious of the relationship between topics, and I wouldn't say there are fundamental differences. Certainly Tladi and Vasquez Bermudez were very active in the development of the customary international law topic, so I don't see fundamental differences between us. I would say that we do try very hard to be consistent. If the Commission, or indeed states in a convention on the law of treaties, say, have come up with a formula, we use that formula unless there's a very good reason not to. We try to keep standard terminology. We don't do anything that contradicts our earlier work. You may think this is unimaginative, unacademic, but it helps to stabilize international law. And I think the Commission, members of the Commission, and collectively feel considerable loyalty to the stability and coherence of international law. We're very conscious that, it's often said international law is a common language or a common grammar even. I think even in the 6 languages of the UN and other languages into which our work is translated, like German and I hope Portuguese, to come up with words like countermeasures. Countermeasures wasn't a word much used until the ILC used it in state responsibility. Now it's clearly understood. People know what it means. It's better than reprisals. We have this loyalty. So I do think that we can't be accused of inconsistency or of contradicting each other, of course. And I think, for example, the formulas we adopted in customary international law are being used in the Jus-Cogens project. Some of the articles are almost identical. And the same perhaps will happen with general principles of law, but that's a very difficult subject. The coordination between the International Law Commission and the Sixth Committee, as I said, is very important. It's also doesn't work very well, and each side blames the other. We blame the Sixth Committee because they don't spend enough time looking at it. The states don't put much effort into replying to us. They tend to be surprised that we even exist. When they know we exist, they complain that we do too much and they can't read a report that's 500 pages long sometimes. How can they read that in 1 month before they have to comment on it in the Sixth Committee? States complain about us, we complain about them. we try to, through personal contacts, keep in touch with states. It's more and more the case that maybe 10 or 15 members of the Commission attend the Sixth Committee and are there able to talk to members of the Sixth Committee in the margins, give lunchtime lectures, that kind of thing. We do our best. But of course, everybody is so busy these days. It's really very difficult to devote for states. I knew that when I was a government lawyer, to devote the time to studying what is a very long-term project. When you're fighting a war in Iraq, how can you devote time to the report of the International Law Commission? Well, you do. And I think the fact that the chief legal advisors are expected to go to New York and speak forces them, they speak in the Sixth Committee, forces them to read the reports or at least understand what's going on. The other thing that the UK does sometimes is hires an outside lawyer, someone from a university, to do the first draft of the comments on that. For example, the UK hired Professor Vaughan Lowe to do draft comments on state responsibility. And he put a lot of work into it. And we put in about 40 pages, most of which I think was probably based on his work, but of course checked by the government to see that it met their approval. So there are ways of improving things, but it is a problem. It's a recurrent problem, but we keep trying. The Sixth Committee has become very naughty in the General Assembly, never turns anything we do into a convention these days. A lot of people regret that a lot. The last convention was in 2004, the State Immunity Convention. On the other hand, a lot of the things we do aren't appropriate for a convention. They are more in the nature they're worth what they're worth. They have influence if they're good. That's true of the topics that we're dealing with. Jus Cogens is going to be just conclusions. No one thinks it will be a convention. Customary international law, obviously nobody ever thought that would be a convention. General principles of law, the same. Now, some states don't like that. Firstly, they don't want to turn things into a convention. But secondly, they don't like not turning them into a convention because that means they don't have any input. We present customary international law, 16 draft conclusions, and they can't change them. They can either say they like them or they don't like them. But there's no forum, unless they create a special one, for them to change them. So in effect, they're allowing us to be the legislature, but not entirely, because they could say, we don't agree, we don't agree, we don't agree. And some of them are very careful in what they say. They say things like, we don't agree with everything, but they don't say what they don't agree with. So they've reserved their right to disagree with everything, in fact. But it's a real problem, and the person who asked the question asks a fundamental question, coordination. I hope that was what the question was addressed to. Thank you.
Well, thank you very much. This gears on to the further question, that is, there has been different criticism regarding the work on the turn to sources on international law by the IOC. One is about the future and impact of such a work, and I would be very happy to hear you on that. Especially, you believe that the work of the Commission is open to criticism and also confirmation by the international courts and tribunals, which can decide whether or not to stick to the project. For instance, one might suggest that ICJ continues to put emphasis in other methods of identification of customary international law. I think that Chagos can be an example. And I think that the Inter-American Court of Human Rights is quite flexible and also criticizable, but they not stick directly to the work of the Commission. So that may be a little bit provocative. Is the IOC becoming something like a professor rather than giving practical guidance to states?
Well, I think there's a danger of that. On the other hand, and I'm not going to say anything about the Inter-American Court of Human Rights, I wouldn't dare criticize it, of course, you're entitled to. But I think that the Commission have been very loyal to the court on the subject, for example, and they traditionally are very loyal to the court. They don't disagree with the court often, very rarely. A colleague of mine has just done a PhD on the relationship between the Commission and the court, and he has a chapter on where there have been disagreements, but they're quite rare. The case, I think, with the customary international law, the Commission followed pretty closely guidance from the International Court. And you mentioned the Chagos case. I don't think there's anything in the Chagos case that is contrary to the Commission's work on identification of customary international law, not in the theory. I think obviously they gave a lot of attention to resolutions of the Security Council on the question of a customary law of self-determination and the point in time when it came into existence. So there are refinements there perhaps. But if you look at the text that the International Law Commission came up with, I don't think the court was doing anything different. I think we were very concise with customary international law. We didn't give all the details, but one thing that might be said, one criticism, though I'm getting into the next lecture in a way, is that it's too rigid, it's too strict. If you apply what the Commission has said, you'll never come up with a rule of customary international law. Well, I'd give two answers to that. Firstly, it shouldn't be too easy to come up with a rule of customary international law. A rule of customary international law is a rule of law binding on states. It's not something you can just pick out of thin air because you're sitting in Costa Rica or wherever. I don't know, but you know what I mean. So it should be quite difficult. On the other hand, what we did is pretty flexible. We gave lots of indications of flexibility, that there has to be a proper methodology, but it's a methodology that can be applied flexibly depending on the context, depending on this. It's not rigid, it's not a numerical thing. So I think that if you read it objectively, it doesn't come down as something that is particularly rigid. But I better not say too much because I won't have anything to say next time.
Okay, good. Thank you for answering me. Leticia Herto from São Paulo asks you which topics that are not currently being dealt with the IOC should, in your opinion, be taken out by it, and also in other way around, which topics are currently being dealt with and should not have been prioritized, which is also a question put by Marina Wunsch. In your opinion, what is so problematic about the choice of topics before the IOC?
Well, problematic about the choice of topics. Firstly, a lot of the obvious topics have already been done, and done successfully, ending with conventions often, or with the state responsibility articles, which are regarded largely as reflecting customary international law by now. If you look at the chapters of any manual of international law, half of them are already covered by the work of the International Law Commission, the obvious ones. So it becomes increasingly hard to find big topics or topics that might lead to a convention. I can think of maybe one or two. I mean, aspects of jurisdiction, which is a very broad word, but there are large parts of jurisdiction that are not codified, that are the subject of debate in the courts. I mean, one topic that's been proposed is that we should study universal criminal jurisdiction. Now, I'm not particularly in favor of that, because I'm partly for political reasons, because the Sixth Committee has made it rather clear that they don't want us to take up that topic. So that's interesting. That's almost an unusual indication that there would, perhaps not the Sixth Committee, but at least the African members of the Sixth Committee want to keep it in the Sixth Committee. They don't want the International Law Commission to have it delegated to it, if you like. But I think there are areas of jurisdiction. There are certainly still areas of immunities which could benefit from being taken up. One proposal that's been made in the last report, I think, is piracy. You'd think piracy was already sort of well covered by the law of the Sea Convention, but actually there's a lot of aspects of piracy, particularly jurisdiction over pirates, jurisdiction of national courts, that could be a subject for useful study. Another topic that I think that I've proposed but hasn't yet been taken up is dispute settlement in respect of disputes to which international organizations are parties. There's quite a lot of the law of international organizations which could be usefully studied. Gaia was keen that we should take up the subject of the immunity of international organizations. I'm not so sure, because there's already so many treaties in that field. But the question of jurisdiction over dispute settlement, there's no access to the ICJ except through advisory opinions, perhaps even binding advisory opinions. There's no, so that's a problem with disputes under international law, but even more serious disputes of a private law nature, following the cholera outbreak in Haiti, for example. UN claims immunity, UN has immunity, but it doesn't look good. There should be perhaps in some way of encouraging the UN to build up its arbitral systems, some way of ensuring that disputes are resolved by a third party without giving up the immunity and putting the UN in the hands of national courts, which is what's happening in a lot of Latin American and some European countries. In Mexico, for example, I think the Supreme Court has said the UN can't have immunity for staff matters because it doesn't have a proper internal system, which is rather odd, but and it's just ignoring, the courts are ignoring the clear wording of the UN General Convention on Privileges and Immunities. So there are real problems. I think that's a subject which it would be very useful, but it's not a big subject. It's something where I think we could contribute. Subjects are currently on the agenda which you shouldn't be dealing with. Well, I couldn't possibly say, but I think they're all good subjects at present. They're very difficult subjects. Jus Cogens is a difficult subject, but I think it's being handled well so far, and I'm happy generally with the way it's going. I think that the immunity of state officials from foreign criminal jurisdiction, which was originally put on the proposal from the Russian member of the commission, Kolodkin at the time. I think we all knew it was a pretty dangerous topic that could go badly wrong. But it's nevertheless a very important topic because states and their courts really need guidance on this. So it's certainly worth trying, and we'll continue trying. But it's taken a long time. It was put on in 2006, and we've not yet done the first reading. And it's been controversial. For the very first time for many years, as you probably know, we had a vote on the key provision.
Interesting. I did not know that. Sarah Tonani asks you a question that is related to this participation of different regions. So Michael would like to know what is your opinion regarding the work of the Inter-American Juridical Committee and the IOC, and what's the difference you see between these institutions, and how to have input from different regions collectively. And perhaps together with Sarah's question, there is an issue that arose during your presentation regarding the national contribution to the ILC, because you mentioned Brazilian different diplomats and lawyers participating in the work of the ILC. And my question to you is whether you perceive some kind of national tradition. I don't know if you can put all the members of the ILC, the British members of the ILC, in the same group, but do you perceive perhaps a national tradition in this regard on sensitive issues or methodology?
Right.
What is your... Yeah, that's the question.
Well, obviously the International Law Commission has members from all the 5 regional groups of the UN, and the numbers are allocated in a General Assembly resolution, so it's a fair balance. When we're sitting in Geneva, the regional groups play no role at all. We're all there as individuals. I don't think any of the regional groups meet to discuss substance. The Western European and Others group has lunch to choose who's going to be our member of the Bureau and who's going to propose our member of the Bureau. These are the 2 decisions we take, and we never discuss the substance. The group just doesn't exist. And Pele used to always say, this group doesn't exist, but we'll have lunch together. And I think it's more or less the same in all the regional groups, so far as I can tell. We're very much there as individuals. The relationship with the regional bodies like the Inter-American Juridical Committee or the Council of Europe Committee on International Law or other ones, well, they do come and talk to us for an hour or 2. They tell us what they're doing and we ask them questions and we get to know them. So there's a bit of interchange there. They follow our work. They often discuss our work. The Council of Europe Committee discusses in detail the International Law Commission's work and that's a useful discussion because it helps states form their views. They hear what other states are saying. Among about 50 states, there's over 50 states attend those meetings. In fact, Mexico attends as an observer. Brazil doesn't, which is a pity. I think maybe you should get Brazil to start coming to Strasbourg. It's also a very nice place to go. But so there's that interchange. I think and we've had the new African Union International Law Commission visitors and tell us what they're doing. I think the Inter-American Juridical Committee is very different in nature. It's governmental for a start, but and it's only 7 members, and it tends to deal a lot of private international law. It tends to deal with things of particular interest in the American context, maybe, which are of interest to the rest of us as well, but it's rather specialized, whereas the African Union Commission and the European one do tend to deal with similar matters. So there can be interchange there, and you often get a topic taken up by one body and then taken over by another or being done in parallel. I don't personally think that having collective input would be a good thing, because that would almost inevitably be a kind of governmental input from these regional groups. And to have, the African group said this, therefore that makes the negotiation of compromise much more difficult. I think we're very much there as individuals. The time can come when it gets to the 6th committee, when it gets to the interstate level, where you can have regional group inputs if that's thought to be appropriate, but I wouldn't particularly want to encourage it. I do, on the other hand, think that contacts between these groups is it's very useful. They all have their own problems, particularly financial problems, for example. There's a limit to how much some of these groups can do.
Thank you very much, Sir Michael. We have 10 minutes. I will make the last round of questions, and then we can finish today. There is a question from Barbara, which is Barbara Solero, which is what weight should be given to the work of the International Law Commission by national courts? I think that this is particularly interesting in regard to the last works on sources. Then there is a question from Damaris, which is, do you believe that the use of soft law as source of international law has already been consolidated? It has influenced the Commission works in some way? And the last question is a more provocative question from Moises. Moises has two good questions. One is about a customer international law that perhaps he could address on Thursday. But Sir Michael, would you care to comment upon the apparent lack of consistent methodology to evidence opinio juris in relation to the jus cogens? I'm sorry, I confused the question. The question is, would you mind shedding some light on whether the lack of authoritative methodology for the determination of existence of jus cogens rules renders the catalog void of content? I think that he wants your views on the product of jus cogens. That's it. I think that these are the final questions. We have a lot of questions, but we had to select them.
Okay, well, to take the last one, jus cogens and the catalogue or list of rules of jus cogens or norms. I hate the word norm, by the way. It doesn't really exist in English. Norms of jus cogens. We've listed 10 in the first reading draft, but we nearly didn't list any. It was sort of 50-50 whether to have a list or not to have a list, because like customary international law topic, the jus cogens topic is meant to be about methodology. It's not meant to be saying what is jus cogens, what are the rules of jus cogens, any more than the customary international law topics meant to say what are the rules of customary international law. So as a kind of compromise, perhaps not a very happy one, we just did a list that is explicitly stated to be a list of norms that the International Law Commission has previously suggested might be or are jus cogens norms. So we've deliberately not applied the methodology that we've set out to determining whether they are jus cogens norms. We've just said we referred to it 30 years ago or 40 years ago, and it's basically the same old list. So it's really very unsatisfactory because there's a list, but we'd say it's got no particular value because we haven't applied the methodology that we've just told you you've got to use to it. So I don't know if that was the point of the question, but if so, I think it's a very good question. The question about soft law, I hate the word term soft law, though I did use it myself. Soft law means it's not law. Soft law is not law. That's the first thing to remember about soft law. The only question is whether something like the articles on state responsibility, which are not treaty, they're not as such practice or opinio juris, they're just a convenient way of setting out what we think the law is. And if you call that soft law, then it can be quite authoritative and can be used by courts, and it's very useful even to the international court and certainly to national courts. So if by soft law you just mean as kind of restatement of the law that is regarded as having some authority, then I think it is useful and its use is accepted. But whether the Commission itself uses soft law, well, I think maybe we do. some of our topics, which have been on things like the protection of persons in the event of disasters. We refer to numerous declarations, resolutions of states, of private bodies, of groups, and we add them all up and we come up with a proposal. But that proposal itself is almost certainly progressive development rather than lex lata. And I think for progressive development, it's certainly acceptable to use anything you can find, really. Which takes us back to the first question. What weight should national courts give to the work of the International Law Commission? I'll answer this in some detail on Thursday, if I may, because I think it's a very interesting question that the Commission itself addressed in its topic on customary international law. But just to answer it very quickly here, obviously it depends on the national courts, because how the national courts receive international law, how they determine international law, depends on their own national legal system. Some do it extremely well. The United Kingdom, sometimes, not always. But there is one very good one I'll tell you about next time. Some deliberately, they say their constitution refers to the general principles of international law or something, so they're given a much fuzzier mandate. We all know the problems the United States has from time to time. Sometimes they're very good, sometimes they take a very narrow view of what they can have regard to when it comes to international law. So I think you can't generalize. It's for each state national courts to have their own system and to determine what weight they should give. But what I would say, and going back to my Swiss Federal Tribunal example, is when they do give weight to the International Law Commission's work, they should be very, very careful in examining it and understanding what it is they're looking at. Is it a first reading draft? Is it a second reading draft? If it's a whichever draft it is, but especially second reading, what was the reaction of states in the Sixth Committee? Was it adopted by a resolution? Was it blessed in some way? Was it heavily criticized in the debate? Parts of it maybe were, parts of it weren't. You need to look in a very, I hate this word, granular way. It's very fashionable these days. At each division to determine what weight you're going to give it. So that would be my answer to that question. But on the whole, if a national court is trying to apply public international law in the way that the International Court of Justice would, or in the way that it should be done, then I would hope that they will give considerable weight to the work of the International Law Commission when it is good, when states have approved it. But not just in a blanket kind of way.
That's a very good answer to the question, and perhaps in the near future, Brazil practice can also contribute to this perception, since we also have right now before our Supreme Court, likewise Ferrini case regarding immunities and regarding customary international law, and perhaps Brazilian practice can also participate in the debate. Okay, so Michael, thank you very much for this very intense and thought-provoking morning. I think, to me, it was a pleasure to have this discussion with you and conduct the questions from our students, and we see each other again on Thursday. Thank you very much, Sir Michael.
Thank you very much. I look forward to that, and I'm only sorry that I haven't met the 700 students. It would have been great fun.
The next time you will. Thank you very much.
Next time. Thank you very much. See you on Thursday. Bye.